Our next presentation is on a subject that is, I think they're kind of two sort of Swiss Army knives for environmental lawyers, that especially things that activists can use. One is CEQA, or the EIA process. The other is the Public Records Act, or Foia, or in EU is sort of the Aarhus. It kind of gives the public the right to information about what's going on in the government. So Mitch Tsai is going to talk you through that, talk about the federal statute, and then the kind of California variant on that, which is called the Public Records Act. There are statutes like that. They're called sunshine laws in many states. So if you're outside of California, you can kind of take the PRA part as indicative of what your state law might provide for, but of course you can't apply it directly. So Mitch is another Southern California attorney who specializes in public interest litigation with a focus on California Environmental Quality Act and land use. Primarily represents public interests like environmental organizations having to do with transportation and infrastructure and development projects to support affordable housing, community benefits, health and safety, environment, watershed protection, and fighting climate change. So he's a litigator like me here in Southern California, who's actively involved and uses these laws every day in his practice. And I will turn this webinar over to him.
Thanks, Dean. Thank you, everybody. Hope everybody is doing well during this COVID-19 crisis. And thank you, Nicholas, for a wonderful presentation. I very much enjoyed it. I've been tuned in for the last few minutes. So thank you very much. And hello, everyone. I hope you're having a good day wherever you might be. So in any case, I'm going to give you a brief overview. Today, I'm going to be talking about obtaining information from the government under the Freedom of Information Act and other state sunshine laws. So under United States federal law, there's an act called the Freedom of Information Act that gives people the right to request government documents. Many states have similar laws that are modeled after the Federal Freedom of Information Act with subtle differences. In this case, since I'm a California attorney, I'll be doing a brief presentation regarding the Freedom of Information Act, giving you a brief rundown on how you can utilize the Freedom of Information Act for your advocacy or whatever purposes you might be, and as well as comparing that to the California Public Records Act and highlighting some of the key differences that there will be. So just to give you, let's just get over to overview. A second, I'm having a brief problem with this. Okay, so now the screen's moving. Okay, so as I said, there's a Freedom of Information Act, as well as state sunshine laws, such as the California Public Records Act. The kinds of differences that I'll be discussing today includes that these kinds of laws differ in terms of the scope of documents that you can request, the process by which by which you are to submit your request and to obtain those documents, as well as what government agencies can exempt from disclosure. One of the starkest differences between the California Public Records Act and the Federal Freedom of Information Act, I think, is quite interesting. So let me tell you a little bit about this. So the Freedom of Information Act is fairly limited in terms of what kind of documents can be discovered under it. For example, it applies only to documents held by agencies of the executive branch of federal government, which means that it automatically excludes most elected officials, including the Congress. So you can't do a public federal FOIA request on, say, your local congressman's, for example, communications with a foreign head of state or that kind of thing, or communications with, say, a local developer or about a certain project, or bank, or for that matter. So that's a sort of a fairly strong limitation. You also can't do FOIA requests on the judicial branch. It only applies to federal agencies under the executive branch of government, which includes which includes a number of federal agencies that many of us deal with all the time, such as the U.S. Army Corps of Engineers, as well as the United States Environmental Protection Agency, the United States Fish and Wildlife Service. It covers those kinds of agencies. Now, the California Public Records Act has a much broader scope. It covers any writing contained in relation to the conduct of the public's business. And it doesn't exclude elected officials. So, for example, you can submit a Public Records Act and ask for whether or not to your local city council member regarding, let's say, I don't know, a highway project, and you can request to see any communications between a city council member and, say, the California Department of Transportation, or for, say, a local developer, that kind of thing. This kind of thing is actually covered under the California Public Records Act and isn't covered under Foia. Another small difference between the Federal Freedom of Information Act as well as the Public Records Act is that the Freedom of Information Act requires that federal agencies make certain information readily available. This is a list right here on the slide of some information that is readily available for under the Freedom of Information Act, which includes guidance documents, regulations, and while many state agencies in California at least make similar records available on their own website and readily available to the public, they're not necessarily legally required to do so under the California Public Records Act. Now, let's talk a little bit about how to submit a FOIA request. The requirements are very simple. You simply need to make a request in writing. California Public Records Act is similar in that same sense as well. However, when it comes to particular state or federal agencies under either statute, there's a specific, each and every single of these individual agencies have their own individual procedures for how you submit a FOIA request or a Public Records Act request. So let's just go into, well, here are some handy tips as to how to submit a FOIA request. Let's just go into an example of how you might submit a FOIA request to the United States EPA. US EPA, as well as many federal agencies, have now gone online, and you can now submit a FOIA request via the internet. And so what EPA has adopted is EPA has a website called foiaonline.gov, which themselves, as well as a number of agencies, are involved with. And so this is an example of what a FOIA request might look like. Obviously, you have to give them your contact information. You have to describe the scope of the documents that you're requesting. And it's important to note that the Freedom of Information Act and the Public Records Act, neither of them requires the agencies to produce information for you. What they do require is that they require those agencies to be able to produce documents that they already have. So if they don't already have documents that pertain to your request, for example, if they haven't done research on, say, greenhouse gas impacts on a particular species, endangered species in your local municipality or local area, then they don't have any obligation to respond to a request that requests information regarding a particular topic if they don't have those documents to begin with. Now, to move on to the next one, so one particular issue that you might want to pay attention to is cost, because under certain conditions, the federal government can charge you for the time as well as the other costs incurred in responding to your FOIA request. And so here is example of where on the US EPA's FOIA online website, you will discuss, you may or may not wish to request that your fees get waived, as well as authorize a certain amount of fees for a particular request, and as well as describe the scope of your request. And so here under FOIA, the Federal Information Act, specifically there is a Department of Justice guidance that discloses when that sets aside when a federal agency should waive or reduce these FOIA Public Records Act requests, namely when it is in the public interest and when there's a lack of a commercial interest on the part of the requester. Now, each and every single federal agency has created its own regulations as to how it interprets that DOJ guidance. But for the most part, and I highlight, in this slide, I'm highlighting US EPA's regulation here. For the most part, I see that most federal agencies have adopted the same standard, which is essentially that commercial requesters are charged for the full fees, which includes records, the time to retrieve those records, and the cost of photocopying them. Whereas news media and any other non-commercial requesters are charged a reduced rate, either based upon the amount of the fees as well as the time it takes to fulfill a request. Now, the Public Records Act is a little bit different. It doesn't allow for a waiver of those costs, but it has a very severe limit on what a public agency can recover costs for, namely just simply the cost of hard copies. So just a rule of practice for those of you who might be submitting a FOIA request, what I would recommend is almost always including in your request a request for the agency to fulfill the request electronically, so that they don't incur electronic, hard copy costs if they unnecessarily. Now let's talk a little bit about the process in which a FOIA request or a Public Records Act request is processed. Now, a FOIA request is when you submit a request, there's a time for the agency to respond to you. And generally under the FOIA, under the Freedom of Information Act, the federal agency not only must respond to you as to whether or not they're going to fulfill your request, and as well as whether or not they have documents that are responsive to your request, but they're also required to produce those actual documents within that time frame. So FOIA requires a federal agency to respond within 20 days. And in the absence, in the extent of unusual circumstances, which can include a need to search for voluminous documents, consult with other agencies, as well as to reach out to other field facilities or establishments, they can extend it for an indefinite period of time. Now, there's an additional regulation that states that if they request a response extension beyond additional 10 days, that they have the obligation to consult with you or work with you to limit the scope of your request or otherwise arrange for an alternative time frame. But here is where a section where the law really gives the federal agency a lot of discretion, is the amount of time it will take to actually respond to a request. They have a lot of discretion to delay response to your request for information. Now, the California Public Records Act is slightly different. It allows 10 days, a 10-day extension, as well as a subsequent 14-day extension under unusual circumstances. But under the California Public Records Act, they only have to tell you whether or not they have responsive documents within those timeframes. In the end, they're not required to produce those actual documents within the set period of time, although they are required to identify to you when they will produce those documents. Now, next step is that we're going to be talking about is information disclosures. So in this particular case, FOIA only sets aside 9 exemptions, fairly broad exemptions for disclosure. So which sets aside quite a bit of room for disagreement. For example, there's some of the more obvious ones, such as information that is classified, information that is related to internal personnel rules, trade secrets or commercial or financial information. That's a fairly controversial source of information, as well as information that is prohibited from disclosure by another federal law, personal privacy issues, law enforcement purposes, which has actually been a really interesting topic in the last few years, given the emergence of video cameras and body cams in particular, and when it comes to police shooting cases in particular, and when or whether a government agency is required, law enforcement agency is required to disclose those those particular body cam videos, as well as some sort of more specific information such as geological information on wells. Now, under the California Public Records Act, the California Public Records Act is different in the sense that it provides many, in fact, 30 very specific but very, very narrow exemptions that are very, very specific as to what they can and cannot exempt. So in this case, under the Public Records Act request, public records in California, there is one fairly vague public interest exemption, which is when the agency can try to exempt an issue for a public for the means of the public interest, but otherwise, these very specific and narrow exemptions are sort of narrowly construed and easily sort of more easily laid out, I'd say. There is less room and flexibility as to what an agency can and cannot exempt under the California Public Records Act. And again, because of the recent body cam videos, there's actually quite a bit of recent law as well as legislative reform on when a police agency has to disclose body cam videos under the California Public Records Act, which generally leans towards disclosure. That's the way it's designed. It's under the California Public Records Act. I'd say comparative to the Foia, the California Public Records Act is a little bit more protective in terms of the public's right to know. Now, under litigation, the process for this process is also slightly different between those two. And right after this section, I'm going to be able to have some time to address some questions. So, but essentially, FOIA requires that you first exhaust an administrative appeal process before you file suit. And it also requires that agencies provide that administrative appeal process, which means that the process for bringing a FOIA lawsuit takes quite a bit of time. And because these administrative appeals can be drawn out and delayed. And so there's a lot more protection for the agency in terms of avoiding the disclosure of information for at least delaying it at least for a certain period of time. There's also a less liberal standard when it comes to attorney's fees. So under the Freedom of Information Act, a court may award reasonable attorney's fees and costs. Now that reasonability analysis is oftentimes based upon how many documents were unlawfully withheld. Now that's different from the California Public Records Act, which requires that mandatory attorney's fees award and cost requires a court to award a litigant their attorney's fees and costs if even one document is unlawfully withheld. So it requires that that if you are able to show even that one page was unlawfully withheld by an agency, that you get the entirety of the fees and reasonable fees and costs that were incurred in this litigation. There's also a slightly shorter statute of limitations in this period, and there's no mandatory administrative appeal process when it comes to the Freedom of Information Act. Now that concludes my presentation. I'm going to move forward to address some of the questions, if I can get to it. Okay, I see it now. Now, actually, the first question I'd say Nick is actually for Nicholas. It's from Jerome from Jerome. Nicholas, would you be interested in taking that question?
Yeah. I don't see the question.
If you hit the question and answer button, it says, it is funny how U.S. environmental lawyers think that they are taking the lead in environmental debate. I object to that. Whereas European environmental lawyers claim the same. However, I have the impression that in Europe, we take the lead in action against our governments, and in the US, you take the lead against the companies polluting. Not a question, only a remark. Jerome, would you be able to tell us a little bit about your feelings about how US environmental law versus European environmental laws when it comes to environmental leadership?
Mitch, the attendees cannot talk on this. So it's really you and Nicholas.
Right.
Could you unshare your screen?
Oh, sure. Absolutely.
Well, it's a very difficult comparative analysis. It seems to me, reading different national environmental law journals, there's much litigation in Europe initiated by NGOs or initiated by residents against undertaking against companies. Perhaps more with respect to listed installation, pollution, or risk. Perhaps far less to climate change issues. So I imagine that with respect to climate change, on the grounds that the state authorities under the duties, EU duties, Paris Agreement duties, to come up with programming, planning, these programs are akin to administrative acts, and they are likely to be challenged in court. So that explains perhaps the recent trend in litigations with respect to climate change. But when it comes back to air pollution or water pollution or destruction of natural habitats, we are in a kind of a classical litigation scheme, individuals, NGOs, foundations versus undertakings.
Thank you. Thank you, Nicholas. Now, the next question is from Mark Underwood, who says that, and we only have one question left, so if anyone wants to submit additional questions, I invite them to. So Mark Underwood states that suppose the EPA or state agency has an air quality monitoring sensor next to a power plant. Can you request a data set from the sensor and any relation to EU open data directives or local adaptations of this approach? Okay, so that's sort of a mixed question between me and Nicholas. I think I would like to take the first half of that question, is that yes, under the Freedom of Information Act or under the California Public Records Act, and I believe most state sunshine laws, although I can't state for all of them, that you do have the right to access air quality monitoring data if it exists. But that's the key part of it, is that I find in many of these cases that that we're not able to even access, or there's not enough data out there available regarding to make an accurate reading on this. And so getting a monitor out there and obtaining the right information, and particularly getting the agencies to go out there and get the information that the public needs, can be a challenge at times. Nicholas, do you have any comment about the EU open data directive?
Yes, I might comment upon a recent Brussels case that was adjudicated by the Court of Justice of the European Union regarding air pollution. The case was not exclusively about the access to air pollution information, but it was also about in which areas to place the different measurement devices. And so the Brussels region took a non-risk approach in placing some of the device in non-polluted areas. And the results were quite favorable regarding environmental quality standards for the region, because several of the devices were actually offsetting the results of this device, were offsetting the too high level of pollutions registered by other devices. And so the claimants contended with that approach, stressing that under the air pollution directive, the 40 or 50 devices had to be installed in areas representative of the amount of pollutions to assess whether the thresholds were exceeded or not. And so in its reasoning, the Court of Justice gave reason to the claimants, say, okay, it makes sense. The argument put forward by the Brussels region was the following one. This is a very technical matter. A court cannot tell us the areas whether we need to place the device next to the motorways or next to the EU institutions or next to the European Commissions. That's our business because it's a technical matter. The Court of Reasoning relates pretty much to my earlier speech, is fundamental rights. We are dealing with a right to life, with a right to breathe clean air. And that means that whenever such right are at stake, the discretions granted to the state authorities is belittled. So
Fantastic.
technical matters discretions is decreasing in as much as one is dealing with fundamental rights, and here it's a right to breathe clean air that's related to the right to life.
That's interesting. Yes. One thing that I wanted to add here, perhaps, is that I would point out that if you're interested in looking at power plants, for example, at least in the under US EPA jurisdiction under Title V of the Clean Air Act, the better way to do it rather than air quality monitoring data is actually the most frequent way in which you can find violations is actually through mandatory operating reports, is that these facilities have to submit reports to the federal government about their operations and their own local data. And oftentimes through that, you can obtain a lot more of the information that you need rather than local monitoring data. Dean, I see one question from Kate Unger. Should I take it?
I don't see the question. What is it?
Oh, okay. Well, Kate says, here is a question. Can you give an example of how you or clients of yours have used Foia or the PRA to get important information and how it helped you achieve your goals, assuming you have time and run out of questions? Well, I think that I can think of two immediate answers, which is that under the California Environmental Quality Act, oftentimes what we see is an agency attempt to piecemeal a project. So, for example, recently we've been dealing with some transportation projects where essentially, when you're commuting into a major metropolitan area, you'll find that there's multiple freeways that this route goes through and multiple stretches of freeways. Oftentimes you'll see a lot of the planning, environmental documentation only pertain to one particular section. So they sort of adopt some sort of kind of shotgun approach where essentially when they have the money to expand one stretch of the freeway, they do so, even though there's a larger vision to do a massive expansion along the whole route of a particular commute, for example. And so in this particular case, what we're doing is we're doing a lot of Public Records Act requests around not only the Caltrans, the California Department of Transportation, but we're also doing a lot of Public Records Act to all the local agencies, because these local agencies will, for example, be talking about, well, if they go to 5 lanes north of us, then it makes no sense because there's just going to be a bottleneck over here. And there's discussions of, so what it is unlawful piecemealing. And so what I see oftentimes in these kinds of projects is that the Public Records Act can really help us obtain intents to figure out the intent behind a particular action. As well as oftentimes sometimes we found information where they've buried a particular biological report where they found endangered species in the site. So that's just one example of one of many examples of effective use of the Public Records Act for advocacy in our work.
Thanks, Mitch. I think your time is up. So thank you very much for a really great presentation on that subject. This is one of the key laws that activists can use. You know, any person can just submit a Public Records Act request to get information from the government, and it's a very powerful tool. So thank you for your presentation.
Thank you, Dean.